trials are running, because we are aware of a directive by the judge president, in terms of which motion and some criminal trials in P1, 2, and 3 are not running today. So we're saying that the equality the equality aspect is implicated. We're not necessarily saying that you have treated him unequally. We're simply saying that you have to say to yourself, does my directive place Mr. Zuma in a different legal or procedural platform? And it does. It suggests that it is okay when it's simple legal arguments or arguments on paper for him to be absent. And that can't be right, because his rights are as good as when he is as good when arguments are being made on paper as they are when there is oral evidence. That distinction doesn't really justify the deviation from the norm. And besides, Your Lordship is consistent with how other courts, including the Chief Justice, has basically reacted to the disturbances that have occurred. They've said, well, if you are going to adopt any procedural mechanisms for the hearing of any parties, those must never deviate from the core rights of the people or the integrity of those hearings must never be compromised because of the issues. So a postponement would simply mean that the hearing of the plea is postponed for a date where parties can assess whether or not the disturbances are such that another procedure can be adopted. And this is not new, my lord, because you will know from the history of this case that parties have in fact agreed to postpone matters because of coronavirus. They've agreed to have the matters postponed, particularly the holding date 1 to date 2, and the reason being given being that the pandemic is a problem. In fact, I can recall that the state itself at some point requested a postponement on the basis that it wasn't clear whether their witnesses who are coming from overseas would be able to come during the pandemic period. And so the matter would be moved forward so that we allow the situation to abate so as to conduct an ideal trial governed by the prescribed constitutional framework. And of course, the taking into account all relevant factors, the nature of the right that is involved. The nature of the rights involved is a right to a fair trial. The purpose of the limitation is to determine. I don't want to give Your Lordship the rationale behind the virtual hearing. The rationale behind the virtual hearing was that there are disturbances and that Mr. Zuma is not present and that there is a pandemic. All three are good, except that there is except that one must look at the other factors, which is the nature and extent of the limitation. The limitation is we can't consult with Mr. Zuma. We can't. The limitation is that he will have to follow the trial or on his plea that may well acquit him virtually. And the difficulties that are the physical barriers that are placed by this virtual hearing are real. And I think the court accepts in its deliberation on whether a virtual hearing or postponement is appropriate route. The relationship between the limitation and its purpose. What here, my lord, one has to look at is you have got two options. The one option is to have the matter here virtually. The other is to hear the matter postponed. Which one will not give any problems in terms of the integrity or the potential constitutional complaints that may arise out of this particular aspect? If there was no coronavirus, if there was no disturbance to the court, if Mr. Zuma was able to physically be in court, there would be absolutely no complaint. What this directive does is that it raises in an already heightened trial a procedural ruling that does not create an ideal constitutional environment for a fair trial hearing. Mr. Zuma would be justified to say that, look at this now. I'm advised by my lawyers that I should be in court hearing my plea and listening to what they are saying about the facts that underpin that plea. But I'm being forced to hear that while I'm in prison. There's so much agency that Mr. Downer and the NPA sees. There's so much agency to have this matter heard. It's 15 years down the line. A 3 months delay takes the matter no further. And there are no risks whatsoever in having this matter postponed. There's no prejudice whatsoever in having this matter postponed. In fact, a postponement would be a justified limitation of this right to have a matter heard expeditiously. Because of reasons of his absence, the coronavirus, and the disturbances, a postponement, as other cases have been postponed, other cases in the same court have been postponed, would be justified in the circumstances. And we would urge your lordship to reevaluate the directive and to order that a postponement be granted.
You're not pursuing the paragraph 1 declaration of rights there?
No, we are pursuing it vigorously, because, my lord, it's now clear from the arguments advanced by the state, because the state says there is no constitutional violation when a virtual hearing is directed under these circumstances. In other words, when there is a disturbance, when there is a pandemic, and when the accused person is absent, there is no constitutional violation in having the matter heard virtually. That's what the state is saying.
I understand that, but can I decide that?
Yes, you have to decide that, my lord, because I'm not even going to. My learned leader has already said to your lordship that don't worry about the fact that you are reconsidering your own directive.
No. It's informed. I hear what you say about reconsidering a directive. It's different to issuing a declaration of rights, though.
Yes, because our opponents, the people who are supposed to conduct the trial, are putting doubts around the rights that are implicated in the directive. And we want that made very clear that today, in future, a virtual hearing will only be an exception, justified by circumstances that are pleaded at that particular point. It is not right for the state, particularly the NPA, to want to treat Mr. Zuma differently. They've been doing that for too long. They must apply the law as they are commanded to do so in terms of the act. This passionate, this zealous pursuit for Mr. Zuma at all costs by bending rules and cutting corners is not right. Let's just have a fair trial. Let's have him in court. Let's have everybody there. Let's argue the case there. Mr. Trenkov can't in good conscience say that it is the platform today to decide the plea, even for purposes of a postponement, because as I understand his argument, he's suggesting that the plea is so meritless that a postponement has no value. That's his view. He has got a mandate that he carries. We've got a mandate to carry. Your lordship must hold the fort, must hold the two reins, and hold the ring so that we're able to fight properly on the plea. And for that, we will debate whether or not we're entitled to cross-examine the averments made on affidavits. We'll have a debate about that later. Today, what your lordship needs to decide is whether or not you should reissue a directive in terms of which this matter is postponed to a future date. And you would be in good company, my lord, if you did so, because you will know that next door to your courtroom are matters that have already been postponed for the same reasons that this matter is being heard virtually. Even civil matters are postponed. They are not being heard because the judge president and others have decided that it's ideal for matters to be heard when there are no disruptions, when there are no potential disruptions to the running of the courtroom. So would say a postponement would give effect to the rights of Mr. Zuma in Section 35(3). A postponement would be consistent with the proper administration of justice. A postponement would enable this matter to be tried on the merits, and no interlocutory applications ought to be easily provoked on either side. So this idea of wanting to cut loose this privilege invited by the court to seek for a postponement, to argue that the plea should be dismissed is with respect not a responsible response to your lordship's directive. Your lordship was quite clear. We're only here for a postponement, and your lordship cannot make an order dismissing the plea or make an order that the plea will go on oral evidence. That will come in its future time. Today, all we're asking is that create the ideal conditions which your lordship is aware of from the writings you have conveyed to us, and which your lordship has routinely practiced under. Just let's be normal with Mr. Zuma for a while, and create no exceptions for him. That is consistent with what our Constitution says in Section 9 of the Constitution, the equality provision. My lord, I am alone here in Cape Town. I am led by someone who is in Johannesburg. I have no idea what he wants me to say as a closing remark. I've got juniors who are both in Johannesburg and in Durban. Now, this is the difficulty. Can I take 2 minutes to find out what my team has to say I should add, including the possibility of asking Mr. Zuma whether or not there's anything I have left which might persuade your lordship that a postponement is absolutely necessary to take.
Yes, Mr. Masuku, it's now 2:05. Oh, sorry, a bit more. How much time do you need?
Can we take maybe 10 minutes?
Yes, certainly. Shall we say 20 past, 25 past?
I'll take the more, 25 past.
25 past. All right.
Yes.
We'll resume at 25 past.
Thank you, my lord.
Mr. Masuku, you ready to continue?
Yes, my Lord.
Let me just do the rounds and just check. Mr. Trengrove, are you there?
Thank you, my lord, we are.
Thank you. And Mr. Roo?
Thank you, my lord, we are.
Thank you. And then Mr. Zuma? Mr. Zuma?
Yes, I'm around.
Thank you very much. You can hear us clearly. Yes.
Yes,
Any further questions, Mr. Masuku, or you?
Yes. No. My leader says he's happy with what I've said, but there are just one or two things that I need to deal with.
Yes.
The first one relates to the.
Yeah. Sorry.
Sorry. The first one relates to the reference to the De Beers case.
Yes.
My lord, you will see that the De Beers case is distinguishable to what is happening here. The question is never, the question that your lordship must answer is not whether or not virtual hearings are permissible in certain circumstances or not. The question is quite different. The question is whether or not the applicant in the postponement has made out a case for the matter to be postponed. We're not here trying to impugn the legality or the constitutionality of a virtual hearing, only to the extent that the declaratory order is sought. But this is not a frontal attack on the dispensation of virtual hearings.
Okay, so if I understand correctly, you're saying that there could be a virtual hearing ordered, yeah? It wouldn't be improper, but you're saying on the facts at present, it shouldn't have been granted.
Yeah, what we're saying, in a trial environment, a virtual hearing should not be granted. And because there is now a dispute with the NPA on that particular dispensation of conducting trials via virtual hearings, it does implicate constitutional rights for which a declaratory order is important. Because they have put it in dispute. They've put it in dispute whether or not there are circumstances. In fact, according to them, this could just be the trial. So we're saying that the De Beers case is not a case that we need to it's distinguishable from the facts of this case. This was an appeal in a Supreme Court of Appeal. It takes the matter no further than just articulating the obvious that in certain circumstances a virtual hearing may be ordered and has been ordered in the past. And then similarly with Regulation 14 that my learned friend referred to, Regulation 14 in its other means should never be extended to mean that a trial can be conducted through a virtual hearing.
When you say trial, you mean a trial with viva voce evidence?
Yes, I mean a trial with viva voce evidence.
Yes. But an aspect of a trial that doesn't involve viva
sorry,
voce.
my lord. Perhaps I should defer to my leader who is watching, and I see he's shaking his head. So maybe I'm doing something that he doesn't like. Can I perhaps stand down and let him?
He says shaking
no,
his
no, I'm happy. I just want to say what Mr. Masuku is referring to was a criminal trial, not just any trial.
Yes. All right. Okay. There we go, Mr. Masuku. Are those your submissions?
No, the last one, my lord.
I think you still have one more to deal with. Okay.
The NPA's opposition to this postponement is of grave concern for how this matter has always been dealt with. In the past, as I've said, there has been an attempt to mutually accommodate each other where postponements were necessary. Postponements has been granted by agreement between parties. And it's quite telling that when Mr. Zuma is incarcerated, that the state would insist that a plea that may result in his acquittal should in fact be debated in his absence, in his physical absence, outside the courtroom, because it favors the state. I do no more than conclude by referring to, in dealing with the argument around the issue of the NPA we deserve, the NPA we must have, the NPA that the Constitution says we must have. It is an NPA that shall serve in terms of Section 32, that shall serve impartially and exercise and carry out or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. What we hear today, that a postponement would, for some reason, the postponement does not violate the rights of Mr. Zuma, but for some reason, the state is insistent that the matter can proceed virtually. Perhaps we should consider virtual imprisonment. And so Mr. Zuma would not necessarily have to be in prison physically in a prison, but virtually imprisoned.
Yeah, Mr. Masuku, are there cases made out for the postponement, or it isn't? Concerns about a particular attitude, I don't think really at the end of the day carry the day, do they?
No, they do, because my lord, you listen to Mr. Turngrove make arguments about how bad the plea is, and make arguments about that it should be dismissed. And I know that's for not, it's completely outside the terms of your directive. But you had submissions that were completely irrelevant for this purpose. And I'm suggesting that the only reason why those submissions were made, and you will see that there's a constant idea of churning out material that will suggest that Mr. Zuma is wasting the court's time, wasting the NPA's time. He should not be complaining about his fair trial rights. That will not happen. Mr. Zuma is entitled to the protection of the Constitution. It doesn't matter what the NPA believes about those rights. He will insist when they are violated. He will come to your lordship, and he will say, please give me a postponement, because what is about to happen will violate my rights. And a lot of people are now asking, why is this trial being conducted virtually when even civil matters are postponed to the 26th of July? What is the urgency? What is this drive that the NPA insists on wanting this particular plea to be disposed of out of hand? They must be patient. They've tried their best for 15 years, and this matter will come before your lordship. The plea will be argued, and Mr. Wim Troost no doubt will make those arguments that he made today. But today was not the time and the opportunity to make those arguments, because those were not covered in the scope of your directive.
Yes, I saw them having a relevance to what is alleged in one part of the founding papers. But I've heard your submission, so let's just, I think we don't have to take it any further.
No. It would be nice, my lord, if I heard you say something like, no, Mr. Masuku, I hear your point, and just leave it there. Because what Mr. Wim Troost said was to ask you to dismiss the plea. He said dismiss the plea, dismiss the application to apply for oral evidence.
Now, Mr. Masuku, I'm dealing with this matter, if it hasn't become apparent now, on the basis of an application for a postponement.
No, it is apparent, my lord. I'm not impugning your lordship's.
No, I just want to. No, I'm not suggesting you are. I just wanted to give you that assurance.
I'll take that to the bank, my lord. My lord, those are the submissions that we make. We ask for a declaratory order. We also ask that the matter be postponed and appropriate arrangements made for a constitutionally acceptable framework under which Mr. Zuma's trial can be conducted.
The postponement that you're asking for, is that a week?
I would suggest 3 weeks. 3 weeks would be appropriate, my lord.
And is that going to suit all counsel?
My Lord, perhaps one of the directives you could make is that council then engage virtually to determine in the third week which dates are suitable for the further conduct of the trial. Because who knows, my Lord? I mean, I know that the state suggests that the disturbances are somehow linked to Mr. Zuma's arrest or incarceration in their founding affidavit. But what happens if, for example, next week there is another disturbance? And there is a need for us to come back to you and to say, my Lord, we've got this problem. Or the pandemic itself comes heavy in the courtrooms of the...
Well, what you say is that the directive might very well still be correct, depending on the circumstances.
Which directive, my Lord?
The one I issued, that it should proceed by way of a virtual hearing.
No.
If conditions should become worse.
No, because then your Lordship must engage with whether or not it's appropriate to conduct a virtual hearing of the trial itself.
Yes, no, but then it'll have to be determined in the prevailing facts at that point.
Yes, because we're here because of the prevailing facts.
The terms in which it has been issued, it might be fine.
No. I've made my submissions on that aspect, my Lord. I'm sure that your Lordship would accept that. That's not what I'm saying. Or what I'm saying is that there is if you do grant a postponement, it does accord with the rights for which the postponement is granted, and it is.
Well, maybe I should then just fix a date if I am so disposed.
Well, if you do fix a date, obviously, if there should be a reason why that date fixed can't be complied with, we will come back to you and ask for. We really don't want to a situation where your Lordship is not in control of the process going forward. If your Lordship feels that a date should be fixed, then your Lordship must fix a date. If your Lordship feels that a better way is for council to engage with each other so that we come with an agreement on the dates, then your Lordship could direct that. And if you can't come with a date, your Lordship can then propose a date.
Yes, the matter was adjourned until today's date, for the trial to continue, wasn't it?
No, we've met the submissions, my Lord. I can't. I can see where your Lordship is going, and I particularly want to say that we accept that the trial was meant to continue today. There were circumstances that intervened for which your Lordship addressed us on, and your Lordship invited submissions. Your Lordship issued directives. There was no need to issue directives.
What I'm trying to clarify, it was set down from now for the next couple of weeks, at least for the session.
No, the conditions won't change tomorrow, my Lord. If the idea is to postpone it tomorrow.
I know that, but I'm just asking, was it not set down from today for the rest of the session?
It was.
Yes. Thank you. Yes. Anything further, Mr. Masuku?
Nothing further, my Lord. Those would be our submissions.
Thank you. Yes. Can anybody still hear?
Yes, we are, my Lord.
Yes,
thank you. This matter is adjourned then until tomorrow. I shall endeavour to give my ruling tomorrow at 10 o'clock. I'm not promising it will be with reasons, but probably with reasons to follow later. But I'll give my ruling tomorrow at 10.
Lord, may I just put on record that for your benefit and of my learned friends, that I am instructed that the prisons have made facilities available to Mr. Zuma to consult with his counsel in one of three ways, either by personal visit, unlimited personal visit, or unlimited use of a Zoom virtual platform, or unlimited use of a telephone.
Thank you. Thank you. We will meet tomorrow then at 10 o'clock.
Thank you, my Lord.
Adjourn until.
Thank you, my Lord.